What happens when an industrial dispute arises between a worker and their employer? The Industrial Disputes Act of 1947 provides a clear process for resolving such matters. Imagine a scenario. An employer dismisses a worker, sparking an industrial dispute. The worker can refer this dispute to the Conciliation Officer, who holds a rank of Labor Enforcement Officer, or Central ALC, or RLC, or DLC, or ACLC, or CLC. This officer's role is to mediate the conflict and find a resolution. However, what if conciliation fails? Here, the Industrial Disputes Act allows the Conciliation Officer to step into the shoes of the central government. They can directly report the failed conciliation to the labor court or tribunal for adjudication. This process is subject to a few conditions. If the Conciliation Officer is of the rank of Labor Enforcement Officer at Labor Commissioner or Regional Labor Commissioner, they must first report the failed conciliation to their regional head. This higher-ranking officer, who holds a rank not below the Deputy Chief Labor Commissioner, will then review the report. If they believe the dispute is unfit for adjudication, they send the report to the central government for further action. If not, they refer the dispute to the labor court or tribunal for adjudication. Similarly, if the Conciliation Officer holds the rank of Deputy Chief Labor Commissioner or Additional Chief Labor Commissioner, they must first report the failure to the Chief Labor Commissioner. The Chief Labor Commissioner then decides whether the dispute is fit for adjudication. Finally, if the Conciliation Officer is of the rank of Chief Labor Commissioner and they deem the dispute unfit for adjudication, they will send the report to the central government. Otherwise, they will refer the dispute to the labor court or tribunal for adjudication. It's important to note that this process does not affect the central government's power to exercise its authority under the Industrial Disputes Act consecutively, regardless of such delegation. To summarize, the Industrial Disputes Act provides a structured process to handle disputes between a worker and their employer. It starts with conciliation, moves to a review by higher-ranking officers, and ends with adjudication by the labor court or tribunal if necessary. This act ensures that workers have a clear path to seek justice in the face of industrial disputes.